call David Clendon.
Thank you, Mr Chair. Mr Chair, I'm pleased to take an initial call on this at this stage. And it was interesting to hear the Minister's comments some few minutes ago. It was a very useful summary of what I consider the mythology that has grown up around the family court and the various issues and problems that are associated with it. And I think it's the overstatement of those problems that leads me to the language of mythology. Like all good myth, there's enough of an essence of truth in there to make them almost credible, but grossly overstated. And that overstatement is used for a very dramatic, a very far-reaching, and I think a very ill-conceived set of changes to the court and the court processes that will resolve some of the undoubted issues that have emerged, some of the difficulties with the court, but at great cost, at the cost of making vulnerable people more likely not to get good service from the court by exposing children and indeed some of their parents to considerable danger at some points. And the language I was referring to in terms of the Minister's contribution, we heard about budget blowout. And yes, indeed, there was an increase in spending. But it's interesting that some of the groups who sought to get a little bit more analysis, a little bit more guidance about how that all broke down, how that shaped up, found significant barriers in their way. We've yet to see a comprehensive analysis of the so-called budget blowout. We heard reference to highly paid lawyers and counsellors as though it's their fault. And in fact, again, that's not sustainable in real terms. We know that lawyers, we heard literally hundreds of lawyers presenting. We heard counsellors, we heard other professionals who work in the family court. And frankly, none of them struck me as being motivated by this very lucrative, supposedly very lucrative place called a family court. Lawyers who want to make lots of money are very ill-advised to go into family court work. We know this. In fact, for that reason, some of the larger partnerships are actually discouraging their partners and their associates from engaging in family law. It is not about people using this as a gravy train, least of all the professionals. We heard a lot about the trivial cases that come before the court. And yes, I've witnessed that personally, not at first hand, I'm pleased to say, but we know, yes, people have used and misused the court to continue their domestic battles by other means, to argue over very trivial issues, often at the cost to the children involved. But these are a minority of cases. We know that the large majority of New Zealanders whose relationships fail do resolve their issues internally. We've heard a great deal about the need to get the state out of these private matters, to leave it to the parents to resolve their own problems. And I agree with that, and most New Zealanders agree, and most New Zealanders achieve that. Very few, in fact, as a percentage, very few cases, whether a marriage or relationship breaks up, do ever come to the court. Some do require counselling and benefit from that, and I agree that that less than $10 million is money very well invested rather than spent. Most couples do resolve their issues. By definition, the cases that come before the court are the hard cases. They are the ones where the individuals, the couples, whatever it is concerned, have not been able to resolve their differences. And yes, we might stand in judgment and say they ought to, as grown-up adults, ought to be able to do that. But the reality is many of them do not and cannot. And in the course of trying to take away their opportunity to use the court as a battleground for their occasionally trivial issues, we're also taking away the opportunity for people with very deep-seated, very real serious issues about safety, about the uneven power within relationships. And all of these are matters which are very serious and that need to be treated as such. And in the reforms proposed to these family court proceedings, we see we're throwing out an awful lot of babies with the bathwater, and I do apologise for the inevitable cliche, but there you are. So there is a great deal at stake here, and it's not again, not to say that the court is not in need of reform. It is a 30-year-old institution, and there are very few 30-year-old institutions that can't stand some improvement in terms of process. And there was a very good, initially, there was a very good analysis of what that was and where it might go. But things did go astray very clearly. And when you get groups like the judges, like the lawyers, like the counsellors, like many people who came to us who had had dealings dealings with the court, some of them good, Mr Chair.
Tandem.
Some of them having had very good experiences in the court, others having had very unfortunate experiences. But we heard about the breadth and depth of the issues the court does confront. Mr Chair, clearly it is about safety of children. Part 1 of this bill amends the Care of Children Act. And the new clause 4 talks about the child's welfare and best interests needing to be paramount, and that's as it should be. And I say with absolute confidence that nobody who sat on the select committee, nobody in this House would dispute the importance of protecting children. Their safety and well-being ought to be paramount, and that's a good thing that that line is in there. There was considerable debate, however, in the committee, and good debate, principled debate about the removal or otherwise of the clauses 58 to 62, the so-called Bristol clauses that were seen to offer another layer of protection where there were allegations of violence against children. Personally, it was a very difficult decision, and I know our party and other parties and members of the committee also struggled with a proposition about removing those clauses. We came down on the side, frankly, there was a very good analysis from the Law Society who spelt out the pros and cons and determined that we could do without those clauses, that there were some negative aspects in terms of cost, in terms of delays, in terms of separation of parents from their children that later proved to be unjustified. And some of the language in new Section 4 and indeed the Section 5 around principles relating to child welfare are seen as a replacement, and that they will be sufficient to ensure child's interests are paramount. But sir, I make reference to the SOP in my name, where I do highlight that there's a possible conflict in some of these principle clauses, particularly when we see that there's a strong proposition that members of the child's family group, whānau, etc., should be involved in the child's ongoing care, but that the child should continue to have a relationship with both their parents. But we also acknowledge that there are situations where with family is the last place that a child should be, because there is danger within that context. And I see so within the principles, and indeed with Section 4, some potential conflict where judges or others might be obliged to try and balance this notion of paramountcy of the protection of the child with this very compelling proposition that families should continue to be involved in the care and treatment of that child. And I do think that this proposed amendment goes some way to removing that potential for conflict, for uncertainty. And it does spell out that in every situation, if there is any sense of, we could make a call one way or the other, that the paramountcy of the safety and interests of the child must be at the top of the hierarchy. Because those principles could be read as a hierarchy, they could be read as having equal weight, and I do think we need to just remove that potential for conflict, that potential for uncertainty, and I do think that that's what the Bristol clauses were originally in place to do, to ensure that there was that we did everything we could to protect children from that situation that could end in that ultimate tragedy, which of course the Bristol case was. So we do see that we see value in the proposition in this SOP, and I do encourage other members to support it and look at it. It's not intended to be a political statement. It's not intended to second-guess any of the negotiations or the discussion that occurred in the committee. It is a genuine attempt to ensure that no judge, nobody is obliged to make that call about which of these principles is at the top of the heap. It makes it absolutely certain, beyond any uncertainty, that welfare of the child, safety of the child must be paramount. Sir, I think I'll leave it at that for this contribution, and we'll look forward to discussing this further.
Mr. Chair. Honourable Phil Goff.
Mr. Chairman, in the bill that we're discussing tonight, we're seeing evidence of a government that is increasingly